Hi, and welcome to another live stream with a live Q&A. I'm Tate Lounsbury with my court coach, and we have here Chris Funtal.
Hey, Tate.
Hi, how are you?
Good.
Good.
All of a sudden, I'm only hearing you in one ear now.
Oh, really?
I can hear you, though.
You can hear me all right?
Yeah.
All right, good. Hopefully that's not going to be weird for you.
Hopefully it's not weird for everybody else.
Oh, yeah. I hope not. Well, welcome to our live stream. We're doing a live Q&A with California family law attorney Chris Funtal. And by way of reminder, everything you see here today, you should not be taking it as legal advice. We're not giving legal advice. Neither Chris are. And we're not giving you any specific tips on or advice on what you should do in your particular case. Instead, these are just general guidelines. Want to encourage you and invite you to go ahead and subscribe to the channel. We do these live Q&As pretty much every single week, every Tuesday. And if you subscribe and hit all notifications, allow all notifications, you'll be notified when we do a live Q&A so that you can jump on the call and ask whatever questions that you'd like to ask. Also invite you to check out our website, mycourtcoach.com, where you find all sorts of resources for people who are representing themselves in court. There are checklists, there are guides, there are templates, there are scripts, anything you could possibly need to know when you are presenting a case in court. You'll find it there on the website. So I encourage you to check that out. Okay, well, what we have planned for today is to go over some of the questions or comments that people have posted as comments to videos. And we're going to answer some viewer questions that way. All right, so let's take a look at our first one. Here we go. This is a comment on our video, how to get a spousal or family support order in California Family Court. This is using Family Court Form FL 343. And this comment says that this is an outdated form, and it is indeed an outdated form. What we're probably not going to do is, or I don't know, right now we don't have plans to redo every single time, redoing another video every single time there's an update to each form. They update these forms sometimes, at the new year is when they'll typically do it. So it can happen frequently. So this one was updated. Although we do have a tip for you. If you are going to here's what you should do every single time. Every single time you're thinking about using a form, what you want to do is go to our website, to our channel, and I'm showing that now. You'll see that there is a list of playlists, and when you go to the very first playlist, it says California Family Law Basics, and you'll see one of the videos in this playlist says find the right California Family Court form. Watch that video. Every time you use a new form, you need to make sure that it's an updated form, and you can figure out how to do that by watching this video. So what we'll do is we'll go over the new form with you today, the new FL 343 form. We'll just go over it briefly for you, and I'll put it up on the screen here. Yeah. Do you have it on your screen, Chris?
I do.
Okay, and I'll pull it up here for the viewers. Might take me a second. Here we go. All right. So this is an attachment form that it gets attached to another form. This is the Spousal, Domestic Partner, or Family Support Order Attachment. Go ahead, take it away.
Well, the top part up here where it says petitioner and respondent, that would just be the petitioner and respondent in the case and the case number. And then the very next block, you check the box for what this is being attached to, findings in order after a hearing or a judgment, or there's a number of things you could check the box for. You could also attach it to a marital settlement agreement. but you check the box for other and then write that in there. And then this next thing is kind of new. It's got a box for the court finds, and then the parties stipulate and agree to the following facts. So it didn't used to have that. Sometimes you have a little bit of both, so I'm not sure that this is more clear than the original. And then the rest of this kind of looks pretty similar to what it was before. You put in, the next blocks down, you put in, what each party's gross monthly income, the deductions usually relating to taxes and health insurance, and if there are hardship deductions, and then the net monthly disposable income. Now, in San Diego County, the way this works is that the court clerk will write up a minute order that has this information in it. So it's easy to get a copy of that minute order a few days after the hearing so you can fill this stuff out. And they've got a lot of information in here for checking boxes like, paragraph 2, and you can go, A, this order attachment modifies a judgment entered on this. But sometimes the judge doesn't state that when they make their order. So I'm not really sure if you're supposed to use that. The judge always talks about gross monthly income and deductions and net monthly disposable income, but they sometimes don't fill in the rest of these things. And you're really only supposed to put the stuff in this order that the judge actually ordered. So I'm not quite sure how that's going to work going forward, if the court's going to be a little bit more specific about all of these parts and pieces of information. As you move on down to the next page, it's got some more information in there. Again, if the court even makes a standard of living finding, then you would put that under 2F, but a lot of times they don't, especially if it's a temporary order pending the rest of the case. Some of these other things like jurisdiction, the issue of support is reserved for later determination, like under 3A. The court would do that if you had a hearing on multiple issues, and for whatever reason the parties weren't ready to go forward on the issue of support. They would simply check this box, and then it would be clear that this is being reserved for a later issue. The next one, the court terminates jurisdiction. That would mean that nobody is going to have to pay the other person's support, no matter what happens. And
so that no one could come back later and say, hey, I want support. If you check this box, that.
Well, but again, this would be something the judge would have ordered.
Okay.
So, if it's done by stipulation, yeah, sometimes people are going to stipulate that neither party is going to pay the other one's support, and then they're terminating jurisdiction. And then, 2 weeks from now, I buy a lottery ticket and I win $400 million. The other side wouldn't be able to come back and ask for even a cup of coffee. But that's something that people routinely do because they want to have some finality and they don't want to keep going back to court.
Right. So it's not that one of these boxes always has to be checked. It's just if any of them are relevant, check it. And if not, then leave it blank.
Right. If the judge specifically ordered it from the bench, or if the parties agreed to it, then yes, you would check the relevant boxes. My experience is most of the time when people have some kind of an agreement, they don't use this form.
So it's possible you could use this form, and 3A, 3B, 3C, none of them could be relevant, right? You could just leave the whole thing blank.
Right. Or depending on, it just depends on the circumstances of the particular case.
Okay.
Sometimes people will agree to terminate the jurisdiction. Sometimes people won't. And so then you would just leave it blank if they didn't. This next box, 3C, the court's jurisdiction over the issue of support will end on, if that's what the court orders or that's what the parties agree to. Sometimes, they make a very specific order that says the amount of support is going to be this much and it's going to be for exactly 120 months. Most of the time, the orders are more open-ended, and usually when the judge makes an order from the bench, they leave them open-ended because the judge never knows what's going to change. I mean, if you've read or if you've watched the other video that my court coach has, a lot of this stuff is pretty much the same. The particular commenter said, "Oh, there's some changes," but they didn't specifically indicate what they had questions about. So it's kind of hard to guess as to what their questions are.
Yeah. Yeah, and like you said, most of this is the same. I'm not sure if they actually had questions or if it was just like a comment. Although yeah. So the other part, all this stuff is still included in the other form.
Right.
Do you see many family support orders? So like that's in section 7.
No, I don't. Not anymore. With the changes to the tax laws a couple, 2-3 years ago, it used to be before that spousal support was deductible to the payor and was includable in the income of the receiver. But that's now gone away. Spousal support is no longer a tax deduction to the payor or a taxable event to the payee. So it used to be you would lump the child support and spousal support together so that you could get a bigger tax deduction from the person paying support so that they would have more money after taxes from which to pay support. And then the other person who might not have any income for tax purposes would then be receiving that money and they would be taxed at a lower rate. The door has pretty much closed on that as far as the changes to the IRS code. The Internal Revenue Code.
Yeah. Okay. Do you have anything more specific to go over on this form?
Nope.
Okay. Okay. Hopefully that is helpful to that commenter. Without any specific questions from that commenter, it's hard for us to give any more specific feedback on it. All right, we have some questions here from live viewers, and let's take a look at this first one. It says, so this first one is a question about dependency court, actually, not family court. And he says, what do I do if I have recently found out that my rights have been severely violated? It sounds like this person was in a dependency hearing. And he says, I have the evidence of where this Child Protective Services worker, the social worker, lied on the stand while testifying, he's saying. And then where the judge just ignored me, stopped the hearing, and then signed the emergency removal order, removal of his children from the home. After the hearing, based off of what the CPS social worker testified to in the hearing, which he says was a lie. And then he said, his sounded like he had a court-appointed lawyer with him, is my guess, in the dependency hearing, and that attorney waived the 10-day due process rights rule. There's a 10-day deadline, or she did when she had stopped the hearing, so I could get an attorney. I'm not sure what exactly happened there, but so the ultimate question, he says, is what do I do about it is what he's asking. I don't handle dependency court, never did. Chris, have you ever handled dependency court?
I've done a couple, and it's kind of a strange thing for somebody that's never been in there. I mean, it's real clear that everybody knows each other and that everybody is working with each other on a daily basis in those same courtrooms. Mm-hmm. And to an outsider, it sure seems like all these people are rather cozy. Mm-hmm. Now, I'm not saying that there is some kind of corruption or wrongdoing happening in a particular case, but for somebody who's losing their rights to their kids, it kind of doesn't always look that great. And this guy's complaints about a particular social worker, I don't know. I mean, obviously I wasn't there, so it's kind of hard to say whether or not why, or specifically why the judge decided to believe this social worker when this poster is saying this person was lying. What do you do about it? There's not a whole lot you can do. I mean, I'm not sure exactly where they are in the proceeding. If it was an emergency removal order, then there will be follow-up hearings, and he has the ability to produce more evidence and try to persuade the judge that he is correct about his position. If it's already a final order of removal, that is devastating. And it's real hard to overturn a final order for removal. So hopefully he's at the beginning of this.
Yeah, he says this was back in 2020. And the way, just for the viewers, dependency court is different than family court. Dependency court is, I mean, it could be the same courtroom or courthouse. Could potentially be the same judge, I guess. But dependency is where the government, through Child Protective Services, is coming in and wanting to remove or restrict a parent's rights to custody of their children. And so that's different than family court. In family court, you have the parents that are having a battle over custody of the children. In dependency court, it's the government coming in. And that first hearing in a dependency hearing is called a detention hearing, where the judge is trying to decide, do the CPS social workers should they be able to remove the child from the parent's home? And so this was back in 2020. Sounds like it was the very first hearing, the detention hearing. What I can say to you is,
it's concerning that it was 2 years ago. So he
Yeah.
should be much further along in his case by now.
It might be over. All right, I see his last comment. That's what I was going to mention to you. We don't know what you're asking for in terms of what can you do about it. You can sue. If you didn't have a lawyer, you don't have a lawyer to sue for malpractice. But he's mentioning his last comments, USC 1983. There's something called civil rights laws, and you can sue a government agency that violates your rights under a federal statute, section 1983. And those are very specialized cases. Not a lot of lawyers handle those cases. There are, that I know of, I'm in that world, although I don't handle those cases. And right now, I'd say there may be like 10 lawyers, maybe 15 lawyers in the entire state of California as of right now that specialize in handling these cases and suing Child Protective Services agencies. One grounds for, as I understand it anyway, one basis for filing this kind of lawsuit is if the social worker lies on the stand. But you'd have to talk to a civil rights lawyer. So I recommend you do a Google search and just civil rights lawyer for CPS and talk to a lawyer about that if you find one who handles those types of cases. And that's your best bet going forward.
I mean, this comment that he makes here, it says, the judge told me that she worked with that team for years and she trusts them. I mean, that's what I was talking about earlier. I mean, you've got all these same people in that same courtroom on a day-by-day basis. And that's kind of hard to deal with.
Yeah. So it sounds like he's already handling a civil rights case and doing this on his own. Maybe he couldn't find a lawyer to help him. Check out mycourtcoach.com. You'll see lots of resources when it comes to actually presenting your case in court. Now, this is when you get to the trial stage. Rules of evidence and how to present a testimony, how to do cross-examination, how to do an opening statement and a closing argument. I don't know that you're at that trial stage right now. My guess is you're not. But once you get there, if you do get there, those resources I think will be helpful for you. Sorry you're going through that, and wish you the best of luck. You're welcome. He says thank you. You're welcome. Okay, we have another
stream of comments from a gentleman named Brian, who's got some questions about DVRO issues. And he has a bunch of comments here, but I think the question at the end, the last two statements he made is, it's difficult to justify obtaining a DVRO at this point because it was so far in the past. And that's probably a very correct statement. DVROs don't age very quickly. or they don't age very well. And so if there was some incident that happened between parents of a child that was 3 years ago, it is very unlikely that a court is going to let you deal with it now. And then his next comment is that the district attorney acknowledged that there was domestic violence, but declined to bring criminal charges. And I can't say why the district attorney did that. Sometimes they prosecute and sometimes they don't. And, usually you have to ask the district attorney, the deputy district attorney, what their reasoning is, and maybe they'll tell you, maybe they won't. But his next question, can the video evidence, because apparently this domestic violence incident was captured on video, can that be submitted at a custody hearing and request that the court acknowledge the evidence and find that DV was committed? Absolutely. Depending on which courthouse you're in and what judge you have, there's probably going to be a requirement that if there's any words that are being stated in the video, that you create a transcript. It doesn't have to be a transcript prepared by an official court reporter. But this way, if you write down all the words in this video ahead of time so that the judge can read along while they're going through it, it's a whole lot easier for the court to have that transcript. And so, at least in San Diego, it's a requirement that these videos be transcribed before you come into court. And again, you can transcribe it yourself and swear out a declaration saying this is what it says, and usually that's going to be acceptable to the court. But if you have evidence of DV, that is powerful evidence in a family law custody case. And absolutely use it.
Yeah, and his very first question, he's talking about the presumption in Family Code 3044. And does that presumption, he says, how is the 3044 presumption applied if both parents have domestic violence within the past 5 years? And I'll go ahead and share that. Should I share that? So what he's talking about is this family code section, which talks about upon a finding by the court that a party seeking custody of a child has perpetrated domestic violence within the previous 5 years against the other party, then there is a rebuttable presumption that an award of sole or joint physical or legal custody of the child to the person who perpetrated the domestic violence is detrimental to the best interest of the child. But that presumption may be rebutted, or it may be shown that it's invalid. So that's what he's talking about.
Right. And then it's critical to understand that even if both parents have issues of domestic violence where the court found that they were doing bad things, that you can cure that by taking care of the issue by doing the rebuttal factors. And, if the person that had been engaged in, committing the domestic violence had a drug or alcohol problem, but then has since sought treatment and can prove that to the court, absolutely the judge is going to look at that. If the person who has committed domestic violence has taken a batterers program, that is something that the court can use to cure that problem. If they've taken a parenting class, same thing. The court will take that into consideration. If the person was on probation or parole because there was a criminal conviction, doesn't sound like that's what happened in this case. But if they successfully completed that probation or parole and they're no longer under probation or parole, that is absolutely something the court can take into consideration to figure out if this person is now somebody the court can trust. And
if also, they didn't do any of those things.
Well, maybe not. I mean, you just don't overcome the presumption at that point. And then, of course, the one thing the court's always going to look at is whether or not there is any ongoing bad behavior from either party. So if there is a protective order in place and then the perpetrator keeps violating that order, that's going to be very bad for that perpetrator.
Yeah, and it sounds like he's saying this happened 2 years ago. And one of his questions was, do I have to file a DVRO, domestic violence restraining order, a request for a restraining order in order for the judge to make a finding of domestic violence?
No,
it sounds like he doesn't want. What's that?
Absolutely not. They don't have to do that. I had a case just like that where husband alleged that wife was doing bad things, and we went to a trial on this thing, and at the trial she never denied it. I mean, she didn't exactly admit it, but she didn't deny it either. And because she was kind of dancing around the issues, the judge finally just said, well, okay, we've got husband's clear testimony that you did this and you haven't denied it, so I'm making the finding. And then the judge applied the 3044 rules, and that was it. So, yeah, you don't have to have a DVTRO. You don't have to have a criminal conviction. And if you've got a videotape, absolutely use it.
Yeah. Okay. He says, thank you. You are welcome. I hope both of you, Chris and Brian, hope that you will like and subscribe so you can get more help at the next live stream. Make sure you turn on all notifications so you're notified of the next live stream. All right, let's go to the next comment in the next video. Good. I'm glad it was helpful. I was responding to his comment there. All right, next one is about, it's another question about a domestic violence restraining order. And this video is a request to renew a restraining order. So this form right here, it's DV 700, is when a restraining order has already been granted or issued, and it might last for 3 years or 5 years, however long it lasts. And then if the protected party is still feeling like he or she is in need of protection, then he or she can request that the restraining order be renewed, that it be continued and not terminate at the end of the 3 years or whatever it is. So here's the video. It's how to request to renew domestic violence restraining order in California Family Court, DV form DV 700. And this commenter says, I currently have 1 more year left. Okay, it sounds like the restraining order is in place and it will be terminating in a year, in 2023. So when is a good time to renew? He or she is asking. And let's just say I can't tell if it's a male or female. Let's just say it's a lady. And the person actually violated the court order in person and by email, by harassing me several times. Is that good enough to renew the request for a restraining order? The fact that it's been violated a few times by emails and phone calls. And this person says that they have kids together, and I'm so afraid if the judge is going to extend it because he also tries to take it away. Sounds like the person who is restrained wants to end the restraining order so that he can have custody of the children. Does that make sense? Any questions? Do you have comments about that?
So the first question is, when is a good time to renew it? You have to renew it before it expires. And at this point, you're a little bit early because you've got a whole year left of a 3-year restraining order. So I would target, if you want to renew it, for 30 days before it expires. It doesn't have to be heard before it expires. It has to be filed before it's expired. And then it says, and the person actually violated the court order. Is that good enough to get it renewed? Actually, that has nothing to do with whether or not it's going to be renewed. A person can renew it whether or not there has been violations of the order. However, I think that's pretty strong evidence to the judge, because if the judge is on a fence about whether or not to leave a restraining order in place, and you can show demonstrable violations of that order, it makes it a pretty strong case for the judge to renew the restraining order. And so I would certainly present that to the judge. And then it says she's concerned because she's afraid he's going to try and take custody. It's a legitimate concern. Obviously, it's a lot more complicated than that. I mean, even if the restraining order goes away, that doesn't mean he's going to get custody. But I understand your concerns in wanting to leave it in place. So I get it. I agree with her.
Yeah. Okay. All right, let's take a look at the next one. This one, it doesn't seem like it's exactly related to family law, although it might be. I don't know. Let me bring it up here. This is a question about how to get money from a lawyer using a subpoena.
Yeah, I'm not sure if this person is a registered process server. I mean, they left that part out of there. If they are a registered process server, then they can sue to get the money back. But based upon the amount of money involved, it's probably not worth it. I'm not sure how much they're owed.
That's a good question. I didn't think about that. So this person says, it's a guy, he says, David, hello, I have a question. I recently served a subpoena in California for an out-of-state attorney. Now I'm waiting for him to pay me. After several emails and phone calls and a request for payment, he has not returned my calls or responded to my emails. What can I do? I think you're right. I think this is someone who, yeah, so some other lawyer in some other state, let's say it's Nevada, just pretending, found this guy, David, maybe a process server, and said, I'll pay you if you go serve this other person. And David goes ahead and he serves him this paperwork. And now this lawyer is skipping out on paying him. David says, hey, dude, give me my money. Right? Is that how you see it?
Yeah, that's how I see the question. But I'm not sure if this guy's a registered process server or not. And that might make a difference about whether or not he can collect. It also depends on what state this other attorney is in, because he's going to have to sue that attorney in another state. And then that would have to be according to the laws of that other state, because that's where the defendant resides. It's a lot more complicated than it looks. And so, my suggestion to people who are licensed or registered process servers is to get paid in advance. And usually you do. You get a credit card in advance or a check in advance. What happens if the check bounces or something? But that's the same problem that maybe this guy is having. And you wind up having to chase somebody. And if it's $100, God, it's sure not worth suing somebody in New York over $100 bill.
Yeah. That's what I was going to say. It's you wouldn't even want to file small claims, petition or court case for this. Probably, usually these kinds of, like you said, it's going to be somewhere around $100. The other thing you could do is you contact the state bar, I guess.
No. They're not going to get involved in something like that. I mean, no, maybe not. But I have no idea what state that this attorney is even in.
Right,
so
I don't know. Keep calling them. I guess that's really all we can really say is keep calling them.
Don't threaten to take him to the state bar. Making a threat like that is actually a serious crime called extortion, and you could wind up going to prison for something like that. So you got to be real careful about threatening to report somebody to the state bar in order to try and get money out of them.
Yeah, we don't know the laws of that state. We don't know what state it is. Maybe there's some rules about it. I have no idea.
And usually when you're talking about service of process for something, you're talking about something that's $100 to $150 at the most.
Yeah.
So I'm not quite sure what's going on or why, but yeah, assuming that state has a small claims court, that would be the way to do it if you want to do it.
All right, so let's go over the next comment. This is on our video requesting temporary emergency orders in California Family Court. And this commenter says that she has submitted forms to Family Court, and the forms were rejected. This is the reason. So when you file forms in court, the clerk is going to take those forms and either accept them and file them or mark them received, or is going to reject them and return them to you and say, here's why we're not filing these documents in court. And these forms were returned back or kicked back to this commenter by the clerk. It says you are asking for temporary emergency orders. However, there's no ex parte hearing that's been scheduled. you're using an outdated temporary emergency order that you've attached. There's no declaration regarding notice and service. And it says your attachments need to be attached to the document they are supporting. And this commenter is asking, can you please explain what this means? I understand my attachments were in incorrect order, but the first part I don't understand. I didn't see that the clerk was saying anything about the correct order. And then this.
Right. Well, I mean, it seems like the biggest problem she has is that she's asking for a temporary emergency order, but she didn't actually schedule an ex parte hearing. And so that doesn't happen automatically. In San Diego, you have to call the clerk before a certain time of the day and say, I need to go ex parte on this issue. And then you need to get your papers to the court to do that ex parte hearing, which would be before noon the day before. And part of that, you'd have to do a request for an ex parte hearing in addition to the temporary order. And you would also have to have some kind of a form showing whether or not you gave notice to the other side. And if you didn't, you have to give the court a darn good reason why you didn't. When it comes to changing any orders regarding custody, visitation, or support, the court is almost always going to want to make sure that the other side has had an opportunity to show up and argue, object, or whatever, unless it's a domestic violence restraining order and it's on the domestic violence restraining order forms. In which case, the court will then read those papers and decide whether or not notice should be given or shouldn't be given. In the case of severe domestic violence, the court is never going to require notice to be given to the other side. If there's been any kind of physical violence, that sort of thing, usually the court's going to address the DVRO on its own without giving the other side an opportunity to be heard at the initial issuance of the order. And then they have everybody come back, usually within 2 weeks, to deal with, the judge getting the side of each side of the story and then making a ruling on what they're going to do with the DVRO. But other than that, you have to give notice to the other side. And I don't know what she's trying to do. I mean, is she trying to change an existing custody and visitation order that was recently made by the judge? I don't know. Is this a case where there are no orders for custody and visitation? And so you have to give the judge a pretty strong case to deal with stuff on an ex parte basis, because otherwise everything would be on an ex parte basis. Now, if the children or the child is in danger, then absolutely the court is going to act and react based upon the allegations that are in the emergency request. But I don't know. I mean, it sounds like it wouldn't hurt to take a look at the videos that you have, Tate, regarding doing temporary emergency orders with the ex parte paperwork, because it just looks like she's missed some things. And there's also, like in San Diego, there's also a checklist that the clerk has of what they're looking for and the corresponding form numbers that have to be filled out, because clearly she's using an outdated emergency order form and she's missing a few things right off the bat. So like you said earlier, usually you can go talk to the clerk and say, I'm not an attorney. I don't understand. What is it I'm missing? And usually the clerks will say, here's the forms. Especially if, children are in danger. They'll spend the time to make sure that the correct forms get filled out. And, it's not up to the clerk to grant or deny the request. But they know for a fact that if it doesn't have the stuff in there, it's not even going to be looked at by the judge. I mean, the judges have very clear rules about what kind of orders they can make with and without notice on an emergency basis.
Yeah, and the court, a lot of times they'll have a packet. So if this is what you're trying to do, an emergency order, here's the packet of all the forms. And I'm not sure which form that she's talking about that was outdated. It could be a local form that in her county that they use, just in that county. It could have been the DV-100, the request for domestic violence restraining order, potentially. I'm not really sure. I only say that because this one was updated. I'm sharing the screen now, so we have a video that talks about this back in that the playlist for Family Law Basics. It's the first playlist that we have that everyone should go through. One of the videos talks about how to read these forms. At the bottom left corner, you're always going to have in each of these forms the date that the form was revised. So this DV-100, it was revised January 1st, 2022. And the video that we have on YouTube that goes over this form, it's an older form than this one. So you always need to go and make sure you're using an updated form. I don't know if the other forms that she might have been using, the FL 305, that was not out. That shouldn't be outdated. The FL 300 should not be outdated. So I'm not sure which one she was using. Okay. She also made a comment on another video. Let me go ahead and share that. It's actually sort of the same comment. I think she says, my documents were rejected by the court. How can I get a hearing so I may keep my Section 8 that was granted, but I need to show proof of income to keep it? My spouse is refusing to help me. I'm homeless and I have several medical problems. See that she's posting this to a video in which we don't go over any forms. This video is just explaining like some of the rules, but no form is discussed in this video. So that's why I don't know which form she's talking about.
Yeah, and I also don't really understand what she's asking for. I mean, whatever's going on between her and the Section 8 authority, I don't see how that has anything to do with the family court.
I don't know.
And she's saying she needs some proof to show her income in order to keep her Section 8 benefit. Well, if she's not working, then all she has to do is declare that she's not working. I mean, how do you prove that you're not working? Now, if she is working, making $500 a month, and that's below the level that she would need to keep it below in order to get some kind of benefit, then she would provide pay stubs showing that she's only earning $500 a month. But I don't really understand how this has anything to do with the family court.
I'm not sure. I'm with you. All right, let's go over to another comment on another video. Boy, today's the day about outdated forms and process, service of process. This question or comment is on our video, find out how much money your ex makes now. This is form the FL 396 regarding a request for production of an income and expense declaration after judgment. And the question doesn't exactly relate to the form necessarily. It says, my brother, this is Selena, my brother was just served an FL 396. The envelope had his ex's return address and my brother's mailing address. He noticed she included a proof of service that had been completely filled out and signed by the server as well. So the person who's serving the document had already filled out and signed the proof of service before actually serving it. And then the process server went ahead and served it. And the question is, from what she says, from what I know, the proof of service shouldn't be signed until after serving the party.
Yeah,
Shouldn't this have been the case since technically he hadn't served my brother yet?
These are served by mail. So the correct way to do this would be to fill out the proof of service form in its entirety without signing it, because it's impossible to sign a document saying you've already served something by sending it in the mail and include it in the same envelope. That being said, I see attorneys doing that all the time. They just sign it and include it in the same envelope. And, this person is right. That's not a correct, truthful way of doing it.
Does it invalidate the proof of the service?
I don't think it does.
I don't think so either.
The question is who mailed it. If it was mailed by somebody other than a party, then that's probably good. And if it wasn't mailed by somebody else, then even then, so your service isn't good. But now you're going to be in court trying to argue to the judge that you didn't feel like providing your income information to the other side. And quite frankly, the court's not going to care. They want this information going back and forth, and they don't want to have to deal with petty disputes about getting documents back and forth regarding people's income. And, I see that in a lot of cases where people either don't want to provide documentation or can't. It happens all the time. You see people, they get a demand for production of documents where somebody is asking for 10,000 pieces of paper, and they go, well, yeah, all that stuff is at the house that I moved out of, and the other party's already in possession of it. And so it's not that they don't want to produce it. They can't. The other party already has it. So, I get it. It's just that the court they don't want to get involved in petty little squabbles. If somebody sends you this form saying, can you send me your current pay stub, then you send them a current pay stub. The part that I find a little obnoxious is that, you got to fill out a whole income and expense declaration. And for some people, that might take a week. It's the old Dick Wolf exception, when he got sued for child support or spousal support, I'm not sure which it was. He said, God, we just went through this thing 3 months ago, and, it took my accountant 6 months to be able to put the information together just to be able to answer that question. And so, yeah, it's kind of a big deal to get that information together for some people. For other people, if you work for a software developer and you get a paycheck every other week, it's going to take you all of 2 minutes. You've already done an income and expense declaration a few years ago, so you can just fill out the same one, make some small changes to it, and attach a current pay stub to it, and you're done.
Yeah.
But for other people who are self-employed, it is a huge burden. I don't know if I want to say that out loud on a video, but my tax returns are always a little bit late because when you're self-employed, it takes a lot to get all that information together and go through all your bank statements to figure out what is and what is not a proper deductible expense. And it takes a great deal of time.
Mm-hmm.
And then you wind up getting some stupid form from somebody for something that didn't happen last year, but then it was something that happened years before, but it has a tax year for last year. And now you're like, okay, now what do I do with it? And so these things just take a whole lot of time. And it's like, the government just goes, oh, God, it's no big deal. Why shouldn't we be able to audit you every year?
Yeah, maybe that's why they would like to avoid this and maybe try to invalidate it if the proof of service is bad. And bottom line, that's probably not going to be any reason why the service was bad. Your brother probably doesn't have any grounds for saying, oh, no, you're going to have to serve this form again because you did it wrong because the proof of service was already signed. Probably not. Just go ahead and move forward.
And then what are they really going to do? They're just going to say, oh, I don't have proper service, so here's another one sent to you again.
Yeah.
All they're going to do is remail the thing out to you. And so all that's going to do is buy you a week of time. That's probably not going to do you a whole lot of good.
Yeah.
On the other hand, if you are Dick Wolf and this is a huge inconvenience to have to do 1,000 hours of work to put together your self-employment income and expense declaration, maybe the right answer is to file a motion with the judge and ask for a protective order. Because usually at that point, the judge knows whether or not the behavior of the other side is reasonable. And most of the time, asking for this form is no big deal and it's reasonable.
Yeah. Okay, I don't have anything more to say on that comment. We do have a comment regarding our the last video that we were watching regarding the Section 8, the last comment that we were discussing. A live commenter says, remember how we weren't sure how the Section 8 was relevant to the family law case? And he says, if she doesn't have a home to have the kids come to, then she will lose them and Section 8. They are very particular. That might be what she is saying. Apparently, I don't really know anything at all about Section 8, but maybe if you qualified because you have kids, and then if you lose the kids, then you lose the Section 8 as well. Maybe, I don't know. I have no idea. So maybe that's relevant.
You do have to have children in order to qualify for Section 8 housing.
Oh, you do?
Yeah, they don't give Section 8 housing to anybody.
Oh, I didn't know.
So I get that part.
Yeah. Anyway,
which one was
comment.
That? Huh? Is that get an emergency? There it is. But that's not what she's asking about in her question. Her question is, it says, I need to show proof of income to keep it, not have an order regarding custody and visitation.
She says, how can I get a hearing so I can keep my Section 8? Remember, this is the one who she filed a request for some emergency order, it sounded like.
Right. I still don't get it. I mean, because she says, I need to show proof of income to keep my Section 8 housing. So it's not clear who she has to show her income proof to. And whether or not her income is high or low, that's not going to change whether or not she has custody and visitation. I mean, the family court is very clear about not dealing with custody visitation based upon giving custody and visitation to people who have more money.
Yeah.
So I don't get it. And if she is homeless and therefore can't have the kids, I mean, it sounds like she's got some serious issues, and she is going to have trouble getting Section 8 housing if she's doesn't have custody of the kids because she's homeless. Yeah.
Well, thanks, Chris, for your comment there. Appreciate that. And hopefully this is helpful to the commenter, to this lady. Another question on the live stream says, if I have questions on how to file something, may I message this? Can I ask the question on the live stream, on the live Q&A regarding a legal question? Sure, come on the live stream. Ask your questions. That's why we're here. What do you say, Chris?
Well, maybe. It depends on what it is.
Yeah, ask your questions, and we'll either ignore it or we'll answer, or we'll do our best to say, well, we don't know, and here's why, and this and that. But ask your question. And just remember, we're not here to give legal advice, and we insist that you not take our advice as specific tips on what you should do in your case. If you want legal advice, if you want a lawyer telling you what you should do, then you need to call and talk to a lawyer who's willing to give you legal advice, rather than just this broad general coaching that we have. That is all the questions. That's all the videos. That's all the comments. Okay, we did it.
We did it.
We're under an hour. This is the longest live stream we've done. I'm glad we have commenters. We're happy to help. Happy to talk about what people are going through, and give more explanations as to what these videos mean, and how to fill them out. As always, we ask that you subscribe. We ask that you turn on all notifications, and that you like this video, and that Chris turn off his phone.
Yeah, it's 7 o'clock. I got to run. It's 7:05.
All right. Thank you all. We'll talk to you soon.
Okay.
Thanks, Chris.